Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am Justice William Meade. With me today are Justices Walsh and Hodgens. Will be the panel for all of the cases today. We have read all your briefs. Each side is entitled to 15 minutes. You needn't use all of your time. If you've hit a home run, you don't need to run the bases twice. My best advice is to get right to the point. With that, I'll call our first case, 24P1234, Commonwealth versus Mitchell. Mr. DeMaria.
Good morning, Your Honors. May it please the Court, my name is Daniel DeMaria for Markell Mitchell, the appellant. Police did not have lawful authority to stop, seize, and frisk Mr. Mitchell. The motion judge denied suppression based on the belief that it was sufficient to find that Mr. Mitchell was armed and dangerous, but the judge never found that Mr. Mitchell was committing, had committed, or was about to commit a crime. The judge relied on outdated reasoning from Fraser and did not take into account that Narcisse and Martin, which are now controlling law, require dual suspicion of both criminality and dangerousness. A suspicion that someone is armed does not equate to suspicion of illegality, since lawful possession is allowed in Massachusetts. The Commonwealth failed to establish that Mr. Mitchell did not have a license. Detective Mancinone claimed that he ran a CJIS check while watching the Instagram video, but that is conspicuously absent from his report in this case. Additionally, he was not at the scene when Mr. Mitchell was stopped.
All right, before we get to that, let me ask you this, because I watched the surveillance video in the stairwell, and it seemed pretty clear that both individuals in the stairwell were under the influence of something. Maybe all the smoke from the marijuana that was floating around them had something to do with it. Now, if you couple that with an officer's observation that he believes someone is carrying a firearm, whether licensed or not, isn't there a reasonable suspicion there that justifies at least a stop?
I would say no, Your Honor. The suspicion from the video Your Honor is referring to is with Luke McKinney. It is not with my client. He's the one that had the hoodie with the bulky pocket. And
they were both in the stairwell, right?
They were both in the stairwell.
It was filled with smoke from marijuana, and they were both exchanging the very large marijuana cigarette, right?
Yes, Your Honor.
And they were both like gesturing and speaking in a way that bespoke some level of intoxication. Wouldn't you agree?
I wouldn't disagree respectfully, Your Honor.
You would disagree?
I would. There was no actual evidence that Mr. Mitchell had diminished capacity. The motion judge found he was, and his words were, very likely under the influence. The judge did not unequivocally find that Mr. Mitchell was under the influence, but also based on the stairwell, I don't think we could say he can't drive a car, he can't have a gun. It was simply, you just cannot tell he's impaired. He's clearly smoking marijuana.
But you would agree you cannot be impaired, whether it be with alcohol or marijuana, and be carrying around a firearm. Would you agree with that?
If you're impaired, yes, Your Honor, I absolutely agree with that.
Okay, and if an officer believes someone's impaired and is carrying a firearm, whether licensed or not, wouldn't you say that there's at least a suspicion that someone's impaired and carrying a firearm, and it merits stopping someone to find out, to determine, is this person really impaired, and should this person be carrying?
I just think, Your Honor, we don't have the erratic behavior. We don't have any intoxication tests when officers stopped him. We have nothing to actually show he was actually impaired. In an OUI, of course, we'd look at bloodshot eyes, odor, and so on, as well as, stumbling and all that. And I would argue that he may have been impaired, but it does not get us there. We can't say he actually was impaired. And there's no mention when he left Mr. McKinney's home and walked to the Audi that he was stumbling or, doing anything that would show that he was impaired.
Why can't, go ahead.
Can I just, getting back to whether or not the police knew that the defendant did not have a valid license to carry, right? So we do have testimony, and I see your point that it wasn't in the police report, but the detective testified that he ran a CJIS, correct?
He did, Your Honor.
Okay. And when I look at the judge's decision, at that very first line at the top, and it says, I credit the testimony of all 4 officers in its entirety. But now you're arguing, in essence, whether something happened or not. When I read that line, I credit the testimony of all 4 officers in their entirety, then don't I have to accept the fact that the judge believed that the CJIS check was done and that it revealed that your client did not have a valid license?
You're absolutely right, Your Honor. The issue is the detective that ran the CJIS check was not on the scene, and
They're all part of the same team, though. I mean, why isn't that the collective knowledge and imputed to Mancione? Is that how you say his name?
So there's no
Moynihan.
There's no vertical collective knowledge because Mancione never said stop that car, and I would say there's no horizontal knowledge. Both in my reply and my opening.
They had watched the Instagram video, right?
Mancione had watched it, and another detective watched a large part of it.
And they were all working together on Mr. Mitchell and Mr. Is it McKinney?
And Mr. McKinney, Your Honor,
Yeah.
that is not.
So it was a group project.
I would disagree, Your Honor. It really, really seems as though they were working separately. The support detectives
Were they working on different things, though, or the same thing?
It was the same thing, but Privé tells us that they need to be in close and constant communication. And I put quotes in both my opening and reply brief that the radio transmissions were very, very scattered and such that even under Privé, I would argue there's no horizontal knowledge.
Why don't we add on the BOLO, where we have photos and video of the defendant with a group that does an armed robbery of the convenience store, and they know about that.
The BOLO, Your Honor, is very suspicious, and detectives...
What they saw is suspicious.
No, I mean, from our perspective, from an appellate perspective, it is very suspicious because the BOLO said they were seeking to identify Mr. Mitchell, but the detectives testified they were highly acquainted with him. So if you accept their testimony, why would they need to put out a BOLO to identify him? And the BOLO also expressed...
Because other officers might not be familiar with him.
But I'm saying for these officers to rely on the BOLO if they're familiar.
But they have reason to believe that he participated in an armed robbery of a convenience store. So they could arrest him for that.
With all due respect, Your Honor, the BOLO expressly stated subjects are not wanted at this time. So I think the BOLO is a red herring. It didn't say armed and dangerous, arrest right away. It said subjects are not wanted.
We're talking about a reasonable suspicion, right? We're not talking about guilt beyond a reasonable doubt.
Yes, Your Honor.
So I don't see why it matters that they didn't want to pick him up immediately for that. They could, could they have arrested him or would they have had reasonable suspicion that he has committed a crime because he's on video and have photographs of him with the group that committed the armed robbery, which is certainly a crime?
I don't think associating with an armed robber or a group of armed robbers in and of itself is a crime.
So that might be a defense at trial, but this is reasonable suspicion to stop him.
You are right, it is reasonable suspicion, but the fact that the subjects were not wanted, I just don't see how that establishes.
It's a quintessential joint venture.
And the fact they were seeking to identify Mr. Mitchell, Your Honor, to me suggests that he may simply have been a witness. And
when we're talking about reasonable suspicion, the police don't have to exclude hypotheses of innocence. So the coulda, woulda, shouldas are taken out of the equation.
I can't disagree with that, Your Honor. But I still think there was no reasonable suspicion. And I think, furthermore, I would say that if we look, so I've argued, number one, that there was no proof of impairment or insufficient proof. Again, the judge said very likely. Secondly, the judge had the entire wrong analysis in that he simply relied on armed and dangerous. He did not take into account the dual criminality. I will say the Commonwealth in its brief relied on Crowder, which I would say is very different because that's an impromptu street encounter where officers simply lacked time to do a CJIS check to see if the person actually was licensed. In my case, they had plenty of time not just to conduct the check, but also to relay it to the arresting team. And there's nothing in the record showing that the arresting team was aware of the CJIS check.
What's your strongest case to support your proposition that the police lacked reasonable suspicion to stop the vehicle?
I would say Commonwealth versus Narcisse because it makes it absolutely clear that police cannot escalate an encounter into a stop or frisk based simply on suspicion that someone is armed and dangerous. That case directly overruled Fraser, which the motion judge relied on. It establishes the dual suspicion rule. It's binding SJC precedent, and it's factually close to our case here. It's a consensual encounter which escalated into a frisk without, in my view, suspicion of illegality. And I would say that we know from Alvarado that mere possession of a firearm does not create reasonable suspicion in and of itself. In Guardado, which is post-Bruin, we know that the Commonwealth has to bear the burden of proving absence of licensure. And we know from Privet, which I touched on earlier, that there has to be close and continuous communication for the collective knowledge doctrine, which is missing here.
Yeah, but I mean, you get at least 3 unmarked cruisers, multiple officers. They all just happen to converge on this one spot. I mean, doesn't that in and of itself indicate they were working together? I mean, was it coincidence that they all just happened to show up at this one spot?
They were acting on a hunch, Your Honor, not on a reasonable suspicion. So you'll recall that, Your Honor will recall that they had a surveillance team watching Mr. McKinney's home. They see my client, Mr. Mitchell, walk from the home to the Audi. They say that his pocket was weighed, if I recall correctly. But that in and of itself is not enough. He didn't make any furtive gestures. He didn't try.
No, but I'm talking about just to show that the police were working together, right? That knowledge of one officer can be imputed to all the other officers because they weren't like just working like independent police details that night out on construction sites. It's pretty clear that they were focused on this vehicle and the occupants of the vehicle.
In my view, Your Honor, we may disagree. I would view it as two separate teams. Marcelin was his own team trying to get a warrant, and then all the officers, I believe they're referred to support detectives. In the record, they're doing yes, it's the same investigation, but they're not in close and constant communication with Marcelin, and they're a separate team, I would respectfully submit. And I would urge the court to look at all the radio chatter I put in both my briefs, and I think that would perhaps, I hope, persuade the court that I'm correct. And if there are no further questions, I would rest on my brief.
Seeing none, thank you very much.
Thank you.
Ms. Payne.
Good morning. May it please the court, Cynthia Payne for the Commonwealth. The Commonwealth is asking this court to affirm the motion judge's denial of the defendant's motion to suppress. The record clearly supports the conclusion that the police officers had reasonable suspicion to believe that the defendant was both committing a crime and that he was armed and dangerous. Your Honors, there were a number of factors that supported this seizure. First, the Instagram feed with Luke McKinney showing the defendant appearing to be under the influence. We see McKinney, who the police officers know, he has a weighted object. Police officer with much training and experience, recognized that to be a firearm and pointed out to the court during the motion to suppress a number of times where he could see that. He also noted that he had viewed this on the computer as opposed to his phone, and the graphics on the phone made it more difficult to see. There was also the incident that occurred 2 months earlier with McKinney. The defendant had been with McKinney at the time. Again, it was an Instagram live feed. McKinney had been arrested with a firearm on his person shortly thereafter that Instagram live feed.
Does the McKinney conduct, can that really have much to say about whether there's a reasonable suspicion as far as the defendant goes? Seems a little tenuous, doesn't it?
I believe it's a factor, certainly, that the court can consider, that McKinney is with the defendant 2 months earlier, same sort of situation, and I think that's just a factor that goes into this. The officers were aware that McKinney was under home arrest. They see the defendant leaving that area. They see him, and he had not, in the Instagram live feed, they didn't notice anything that appeared to be heavily weighted, but when he leaves McKinney's residence, he walks out with something weighted, and he appears to be attempting to hold on to that as well. So again, I believe that could be a factor. The officers noted that known associates of the defendant had been arrested for firearms. They noted that he associated with gang members, although he was not a recognized gang member himself. They noted that 4 days earlier there had been the shooting and armed robbery at the gas station, which was in that area. So the Commonwealth would suggest that certainly all of those incidences supported the stop of that car. The Commonwealth acknowledges that the motion judge might have been incorrect in finding that the stop occurred later than it actually did.
I was going to thank you for your concession, but now you seem to be walking it back.
Oh, I'm not walking it back.
Okay.
I'm not walking it back. I'm just trying to be tactful. But I would suggest that as soon as they stop the vehicle, the officers testified that they see the defendant make some sort of movement, and at that moment, at least 2 of the officers testified that they became fearful. They had reasonable suspicion to believe that there was a firearm, and that gesture, I would suggest, certainly supported the exit order, and I would suggest that that also would have supported a pat frisk. But when the defendant exited the vehicle, I would suggest the testimony was that in plain view, I believe it was Officer Lewis, saw the firearm in the defendant's person or in the pocket, I would suggest that but all those factors supported the reasonable suspicion that the defendant was committing a crime and was armed and dangerous, notwithstanding the fact that Officer Mancioni had run the CJIS query. Commonwealth would suggest that this was a team working together. These were support officers. They were in constant communication. I know there was not as much contact between the two, but they were staked out essentially in front of McKinney's home while the Mancioni was watching the Instagram feed.
Now, that CJIS check didn't show up in the police report, though, right?
That's correct. That's correct.
And we to do anything with that, or is that for the motion judge?
I would suggest that that was the motion judge. The motion judge, as Justice Walsh pointed out, credited the officer's testimony, all of the officer's testimony in its entirety. I would suggest that that was the motion judge's call to make. He believed, but even if this court were to discount that, but I would certainly not concede and not backtrack at all, I would suggest that there was certainly enough that the officers had both reasonable suspicion the defendant was committing a crime and that he was armed and dangerous.
Can I just get back to that?
Of course.
I understand that you're not conceding, but I'm failing to understand if you don't have other officers having any information that the defendant doesn't have a license, how do you get to reasonable suspicion without it?
Well,
It's laid out and it's a high crime neighborhood, okay? But you just said even if we were to not believe that the collective knowledge and imputed knowledge doctrine applies here.
even if you were not to believe that the collective,
Maybe I misheard you, but I thought you would just express that even without the testimony about the CJIS check, you still have reasonable suspicion.
I'm not conceding that. I am just attempting to further the argument that there was enough even without that. I would suggest also, under the fact that it was very clear, certainly to anyone who watched the Instagram feed, that the defendant appeared to be under the influence. The officers were concerned about that. The motion judge made that point. I would suggest, they had the right to stop the vehicle, and then what happened? Then they noticed him making the gesture. So I would suggest that the court can get to the motion judge's correct conclusion, albeit not necessarily in the same way that the motion judge did. I know that roundabout answers your question, maybe.
Thank you.
Unless the court has any further questions, the Commonwealth
Seeing
would
none,
rest on
thank
its
you.
brief.
Thank you both.
Thank
We'll
you.
take it under advisement.
Nice job.
This case in our meat locker. Is it really even on? The next case in our very chilly courtroom is 24P 843, Commonwealth, Commonwealth versus Maderos. Mr. Rawl.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Ryan Rawl for the Commonwealth on behalf of Middlesex. Back on May 9th of 2016, the defendant, Linda Maderos, pled guilty to an extensive scheme that involved stealing over $1.4 million in her trust as a bookkeeper for the victim in this case, Ms. Mockler. She signed blank checks for expenses and then wrote them to herself for personal benefit, including cruises and vacations to Ireland and Italy. As part of that negotiated plea on the day of trial, the defendant agreed to a 10-year probationary sentence. There was a disparate sentencing discussion about whether she should serve 3 to 4 years in state prison or house time. Chief Justice Budd, now Chief Justice Budd, gave 3 to 4 years in state prison followed by a 10-year probationary sentence. The question before this court is whether the motion judge, years after the fact, abused his discretion in terminating the probation when it was only half completed and vacating the restitution order. The answer to that has to be yes. And the reason for that is because the motion judge had no authority to do such a thing. And if you go through the filings, the legal basis that the motion judge relies on, it says, well, this predates Henry. And so I have the authority to completely revise and revoke this probationary sentence and terminate it early. And
The judge has that authority, doesn't he or she?
She does not, or he does not. And the reason is straightforward, and it's actually contained in what the defendant relies on principally in their brief, which is the Goodwin case. And so in Goodwin, the court addressed the difference between removing or modifying conditions of probation after the fact and changing the sentence. The court has very circumscribed authority to revise or revoke a sentence and change the probationary length. That's governed by Rule 29. It's discussed in Goodwin at length. And the court, if it's not within the 60 days, doesn't have the authority to completely and materially alter the sentence. Importantly, in Goodwin, the court actually confirms this by saying when the court added conditions, it materially changed the sentence. So clearly, if you add conditions that make the sentence more punitive, that's considered a material change to the sentence, and they said you can't do that under Rule 29. So if just changing the conditions can cause that, clearly cutting the length in half for an individual who stole $1.4 million is not lawful. While the court relied only on Henry without any guidance or legal discussion as to why, it is clear in reading Henry that, first of all, Henry does not give the motion judge the authority to do this. What Henry addresses is for people who have the inability to pay, that they not be suffering extended probationary periods or be violated for their inability to pay. It's a well-established principle. I think everyone can agree that it's reasonable. But what the judge did here was turn Henry on its head and took an individual who could pay, was making payments, and had a Henry hearing back in May of 2019 where she agreed to make payments of $400 a month and said, well, she's paid some of it, she's done a good job on probation, I'm going to terminate it early under Henry. And there's no authority in Henry for that proposition.
Let me just ask you this, just putting Henry aside for 1 second. So this is the third judge who touched this case, right? And if someone's on probation for a long period of time, there's a possibility that multiple judges may touch the case. So if you have a judge down the road who simply disagrees with something a prior judge did, just disagrees with it, does that judge, that last judge to touch the case, does that judge have the authority to change what a prior judge did?
No. And it's clear from Rule 29 and the rigid guidance. There's the ability to revise and revoke a sentence is within the 60-day period and 60 days from the rescript of the appeal. And to add to that, there are numerous aspects that actually do reduce the sentence. So there's a statutory provision that 276, Section 84B, where you actually receive compliance credits while on probation and your probationary sentence decreases as a matter of legislative authority. But in terms of the judge's discretion, the answer is no. The sentencing judge gave a lawful, lengthy probationary sentence in this case. This individual stole over $1 million over a long period of time, and the conditions of the probation were geared to protect the public and all of the goals, rehabilitation, deterrence, but also to attempt to assist to make the victim whole.
I disagree on part of your proposition. I think on the 3 to 4, sure. In 60 days, if there's not a revise and revoke, there's limited options. But the intention of probation, especially over a significant period of time, It's a living, breathing entity for the most part, right? And so it changes, just as people change. And so you're telling me that on a 20-year probationary sentence, at year 15, when the defendant has been clean and sober and abided by all the conditions and paid back all the restitution, and the chief probation officer has a big award in his or her hand and says, we want to terminate early, and the prosecution says, absolutely, Judge, we do too. This is a remarkable change. The judge lacks authority.
So I'm not arguing that extreme of a position in this
So the judge
case.
has authority to terminate probation.
I think that combined with the statute, which creates compliance credits to allow early termination,
So the judge has authority to terminate probation. The judge has authority to modify conditions of probation, so long as the judge does not abuse his or her discretion, correct?
I think that I'm going
Commit
to,
error of law.
I think I'm going to clarify my position a little. And I think the reason I'm going to clarify it is clear from the case law, you always have the authority to modify conditions. And if I wasn't clear initially, I will be clear here. The ability to change the length of the sentence, reduce the length of the sentence, is much more limited. And the authority for that can come, and the defendant does cite, that the sentencing judge themselves can say, and it's encouraged to do so, as part of the sentence, the sentencing judge can say, if you comply and do things well, come back to me or come back to the court, and I will consider terminating it early. And
Even without that, I'd suggest that the judge has the authority to terminate probation in appropriate circumstances. Having said that, does your argument still hold water?
yes, because I think the narrow issue before this court is whether this judge abused his discretion relying on Henry. And I think it is clear that Henry has no applicability. In particular, when you look at the facts of the motion hearing, the defendant was not claiming she couldn't continue to pay. The defendant could continue to pay. The reason she gave at the hearing was, I think the probation is too long, and I would like to not be on probation when I go to my daughter's wedding in Italy. Even though there had not been previous issues when she went on a cruise to the Bahamas.
I know you argue that Henry was complied with, and Henry was decided before this defendant was sentenced, right?
Right.
And this is not the defendant's direct appeal.
Correct.
This is an appeal of a collateral order. Why does the defendant get to apply, or the judge get to apply Henry retroactive to this defendant?
Well, we argued they did not. They did not have the authority to apply it retroactively.
I don't think I saw that in your brief.
I apologize, it was unclear, but I think we're saying that Henry does not allow the judge to do this. I think included in that and within the filings below, we did argue that it wasn't retroactive. But in particular, though, I don't think that needs to resolve the issue. The court needs to not decide the retroactivity because there's no basis.
We could end our inquiry right there. The judge based it on Henry, and if Henry doesn't apply, that's the end of the story.
Well, I think I agree, but even more so, Henry was complied with. So
No, I know, that's why I said I got that part. And certainly that's why Judge Tutman held the post-incarceration hearing, right?
Right. So I think the combination of having the Henry hearing after the fact, but also the way that the sentence was imposed, complied with Henry. If it was not clear from the Commonwealth's brief, I will add that the Commonwealth argued and continues to argue that Henry does not provide that authority in this case. And that includes the fact, besides that Henry was complied with, that in the vein of Rule 29 and revise and revokes, that it was not retroactive. There's no case law, there's nothing in Henry that gives the authority generally to do this, but it certainly didn't give the authority to be retroactive on sentences before it. I would just like to end with, this is not strictly a restitution issue case about the conditions of probation. I think there's more to what the goals of probation are here. And this defendant, one of the main conditions was to not have employment in a role in which they could have financial control or operate as a bookkeeper, and that's an important aspect of the sentence as well, and nothing has changed about the need for that to protect the public. I just think when you look at the reasons provided below by the defendant moving to terminate the probation, there's no legal basis to do so. Citing the sentencing guidelines or best practices.
Which also post-date the sentencing in this case.
Correct.
By years.
But they're not binding in any way. They don't have any legal authority. I think when you look at the filings of the defendant below, but also the judge's findings and the findings and their argument in the brief, you won't find legal authority for the proposition that the basis they submitted is a basis to completely cut a probationary sentence in half. And as a comparison, the sentencing guidelines, to go back to Justice Walsh on the reference to the sentence, one could not argue that, well, the sentencing guidelines in this case were 12 months to 36 months, so the judge, you have no authority to sentence above that, right? It's the same logic with probation. As long as the goals of probation are met and the sentence is lawful, the ability to revise and revoke that sentence and cut it in half in this case, reliant on Henry as the basis, is just an abuse of discretion. And for those reasons, if there's no further questions, I'll yield the rest of my time.
Thank you.
Thank you.
Ms. DeVore.
Good morning. May it please the court, Melissa DeVore for Linda Maderos.
Can you start with retroactivity?
Absolutely, Your Honor. I would suggest to the court that Attorney Early and the judge both discussed whether or not the question was whether the judge needed to, under the law, readdress probation and end probation pursuant to Commonwealth v. Henry. And what the judge said was, I just want to make sure that this is a discretionary function of the court as opposed to something I'm required to do under Henry. Attorney Jean Early for Ms. Maderos also told the court that she, too, I agree, and this is a quote, I agree with ADA Van Epps that Henry does not require this to be relitigated.
Okay, so back to my question. Henry was decided after this defendant was sentenced.
Yes, Your Honor.
And we do not apply case law retroactively to cases on a collateral appeal. A direct appeal, yes, collateral. This is collateral. I assume you don't dispute that this is not a direct appeal.
I don't. Attorney Early didn't dispute that either.
So you're familiar with Teague versus Lane?
Pardon?
Teague versus Lane. The narrow exception to retroactivity involves watershed rules of criminal procedure and decriminalizing classes of conduct. I assume you'll tell me that Henry is neither of those.
Correct, Your Honor.
So how do we apply this retroactively?
You don't have to apply Henry retroactively, and that's not what
the judge based his decision on Henry.
What the Commonwealth then filed a motion to reconsider, both to reconsider and to clarify the court's ruling, and Justice Tingle said in his motion to reconsider, the court has discretion upon motion to terminate probation early, as was done in this case.
See, this goes back to my original question. So the original plea is in 2016. Judge Tutman changes the probation in 2019, and then 2023, probation's terminated by a third judge. So my concern is, now we had the victim here was in her 80s. So I don't know if she's still with us. But over time, the voice of the victim tends to get quieter and quieter until it's not heard anymore. But the defendant's still out there and can come back to court and say, geez, Judge, can you exercise your discretion and change the conditions of probation? So there has to be some governor on that. It can't just be waving a magic wand and saying, I have the discretion to do it. There must be some standard. So I looked into this briefly, and it looks like Judge Katzmann of this court gave us the answer. In Commonwealth v. Morales, 70 Mass App Court 839. He said, in conditions amounting to a material change in circumstances, the court may modify the conditions in order to serve the ends of justice and the best interest of both the public and the defendant. So what circumstances changed? Because the judge didn't indicate he was relying on any changed circumstances.
No, Your Honor. I think what the judge was relying on was the precedent that a judge, upon a motion by a defendant, has the authority to vacate probation early. And that precedent comes from Goodwin, which says that where a defendant has complied with his conditions of probation, a judge's authority under the law to modify or add conditions are limited, but where a defendant has performed so well on probation and made such rehabilitative progress that the conditions imposed on him should be relaxed, a judge may eliminate or modify a probation condition even if this diminishes the scope of the original probation conditions. In addition, the Superior Court Best Practices Group also encourages practitioners to file motions to vacate probation and terminate early where a probationer has been performing well.
And those were promulgated 3 years after the defendant was sentenced.
Yes, but they stem from, I believe, Goodwin and years as a practical matter of practice of defendants filing motions in court to vacate probation early.
Okay. Can I return to retroactivity? There was a motion for clarification, and you said the judge, yeah, I have the discretion to do this. Did he say did he strike his prior decision?
No, Your Honor. I think what he was saying was that Henry was certainly a factor that guided his decision. But there was other evidence presented at the hearing which also supported his decision. For example—
What is that evidence? Because I'm having a hard time. I understand your argument, but based upon the facts of this case, in which it appears that some thought and consideration and negotiation went into a plea that included a significant period of restitution, time for restitution, and to protect other people from being victimized by Ms. Maderos, that what changed? Because, frankly, this isn't the situation where the evidence is clear. She paid back $1.4 million, then some, and then did something else. And you say, when balancing the public interest and the interests of the defendant, et cetera, which, by the way, has to do with modification and relaxing, not vacating, right? Or terminating.
Yeah, well, I
That
think
quote.
you can modify, by modifying a term of probation, I would suggest that the term includes the length.
No. Modifying is a condition of probation. There's a modifying and relaxing conditions of probation, which is what was suggested, versus terminating probation. But that putting to aside, I can't tell from reading this decision or margin finding what the judge based his decision on. Can you?
I would agree with you that the judge did not explicitly list out the factors that I laid out in my brief. That's, I would suggest, inferred by listening to the argument and seeing how he ultimately decided the decision. I would agree with that, Your Honor, that he doesn't explicitly lay out the factors.
How do we tell whether a judge, if it's an abuse of discretion, if we don't know? So if it was, for example, I want to go to Italy and not be encumbered by probation, sounds like an abuse of discretion to me to say that that fits within public interest and the rights of the defendant.
Your Honor, in LLV Commonwealth, the court talks about what is an abuse of discretion.
Well, I'm familiar with that standard, but tell me again, if the record is silent and you are, in your brief, appropriately trying to fill in the blanks, What's your best-case scenario for why, other than best practices, of why the judge terminated probation here?
Well, I would suggest to the court that even the Commonwealth wasn't able to submit to the court an argument as to why the judge was out of bounds to make this finding, where she had been doing so well, where Ms. Maderos had in fact done the treatment. She was described by probation as having been doing, I think Ms. Early described her as a model probationer.
She was ordered to pay $1.4 million, did she?
No, she did not. She was
not
never,
done.
as a practical matter, and I think everybody agreed, it was unlikely that that was ever going to be
But her
achieved.
job was not done yet, was it? Doesn't she still owe about 1.3 million in change left?
Likely. However, Your Honor, I would also suggest that even if she had completed all the conditions, at best, it would have been about $48,000, I believe, that was going to be paid back.
And she didn't pay that either. She only paid about half of that, right?
That's right. And of course, that's why we'd have the person who was out that money, they'd have to seek other avenues. And,
And she, the defendant agreed in front of Judge Tutman that she could pay the $400 a month.
Yes.
I'm just trying to have an overall hard time picturing when Justice Hodgens earlier talked about the voice of the victim getting quieter or quieter. If the victim were still alive and waiting for that $400 check, and the defendant goes into court and says, I want to go to Italy, and I don't want to be encumbered anymore and have to pay anymore, tell me how that isn't an abuse of discretion by a judge saying, that's enough.
I would suggest that the judge didn't just say, well, I know you want to go, that's enough. That
What else was there? What did I miss that was?
that she had been doing so well on probation for 5 whole years, that she had, in addition to serving a 3 to 4 year prison sentence, then got out, maintained employment, provided proof of her employment, met bi-monthly with probation, submitted a DNA sample, made the monthly restitution payments up until that date, successfully completed those 5 years of probation. All of those factors.
Yeah, but and that's all wonderful, but in the end, she never disgorged the ill-gotten gain. She made off with over $1 million. And she's only paid back about 20-something thousand, something like that?
I don't think it's fair for us to infer that fact, Your Honor. I don't know, as I stand before you, if there
Well, she
was
admitted
a
to
civil
that.
judgment.
She admitted to that at the plea, didn't she?
I don't know today, because obviously the victim had civil recourse. So I don't know if the victim ended up, I don't know what Ms. Maderos's personal financial resources were since then, if she has had any reason why the victim hasn't been able to civilly recover more than what was gained through restitution.
The defendant admitted that she stole over $1 million from an elderly woman who she was supposedly taking care of or helping to take care of. And she never had to pay it back. Crime pays.
Well, I disagree with that, Your Honor, because there are mechanisms in our justice system for a victim to get paid what they have lost. And our courts have found that ultimately it doesn't live or die in the criminal justice system. It's not the role of restitution to hold somebody on probation until they've repaid that entire $1.4 million amount. There's other purposes of the repayment. Instead, I would suggest that the victim will always have the legal recourse to go and get that money paid back to them. The mechanism is not solely through this criminal case.
So you're suggesting that we should just pitch the whole thing?
No.
That we shouldn't, in cases where someone steals money, that restitution just shouldn't be ordered, it's just not worthwhile?
Absolutely not, and I don't know why the victim wasn't brought in and why nobody asked. There was never I read through the record, and I saw at one point, I believe it was the probation officer mentioned that the victim hadn't been notified, but no one stopped the hearing and said, in Your Honor, we're asking for another date to notify the victim. That happens as a regular practice. I can attest to this as a trial practitioner. We regularly continue court dates so that the victim has an opportunity to come in. And nobody, the probation officer nor the DA came and said, Your Honor, we need another date so that we can talk with the victim and have the victim come in on this motion to terminate probation early. Why that was not done, I don't know if it was because they didn't think to do it, if the victim wasn't available because they had passed away. I don't know. But the fact that we didn't get to hear from the victim was certainly not the fault of Ms. Maderos, and it was never something that anybody requested that the judge denied, such that now, looking back on it, this judge's decision should be reversed. I see I have just 30 seconds remaining, Your Honor. The only thing I would point out to the court is I do believe that this is the first time that the Commonwealth has raised the issue that this is an abuse of discretion and not an error of law. And so that is the standard.
Well, an error of law is an abuse of discretion.
Pardon?
An error of law constitutes an abuse of discretion.
But I would submit to the court that in this case, the judge did have the discretionary authority. It was not just solely based on Commonwealth v. Henry.
I understand.
Thank you.
Thank you. I'll take it under advisement. The next case is 24P1151, Commonwealth versus Marcelin. Ms. Sandman.
Good morning. May it please the court, Joanna Sandman for William Marcelin. The basic tenets of due process were not satisfied here. The written modified order was, at best, ambiguous, and due process requires that that ambiguity be resolved in favor of Mr. Marcelin under the rule of lenity.
Could the
Failure to
defendant
do
go
so-
to the plaintiff's apartment and go inside and walk in?
I'm sorry, Judge, can you repeat that? I didn't hear you.
Would it be a violation of the restraining order as modified for the defendant to have gone up to the second floor and walked into Mom's residence?
I think potentially there's also, in addition to the stay away 5 feet from, I would suggest to the court, the plaintiff's person, there was also a no contact order as well. And I understand sort of what the court is getting at, which is this modification was not a model of clarity or perfection. And I think—
Excuse me, can you just bring that microphone closer to you?
Absolutely.
There you go. Thank you.
That said, that doesn't fall on Mr. Marcelin under due process. Those ambiguities still need to be resolved in favor of a defendant, and that it is prejudicial error to not have resolved them in that manner, and that error was compounded by the trial judge's refusal to rule on the terms and conditions of that modified order, and essentially improperly leaving it to the jury to determine the terms and conditions of a court order.
Was that objected to?
No.
Not only was it not objected to, it appears from reading the trial transcript, right? You know what I'm going to say.
I do.
Okay. So
And I would say to the court that the trial counsel did not perhaps handle the case in the perfect way, but her argument, I would suggest, lends credence to that concept of ambiguity, right? I mean,
or, right? Or when you look at the terms and what due process requires is a common understanding of the terms. And when even defense counsel is arguing about staying 5 feet away from the unit, that's what defense counsel's understanding was.
Well,
That's what the prosecutor's theory of the case was.
I would point out to the court a couple of things. First of all, at trial, yes, that was the way that trial counsel presented it. Prior to trial, both at the motion to dismiss and at the arraignment and following the conviction, the defense attorney did present the argument that it was 5 feet from the plaintiff, or at least that was what she believed she should have argued. So while I do concede that that is the argument that she made, first of all, that argument or opening and closings are obviously not evidence, and we have to look at the order itself. And I do think that her mistake, again, really supports that argument that this order was ambiguous, and so ambiguous that a person of common intelligence would not have necessarily known the prohibited conduct, and therefore couldn't be found in violation of the order without violating due process. And I would also just add that if the court is inclined to clarify the record by allowing that motion to expand, I do believe that that prejudicial error is even more stark, because the court's oral order during the extension order hearing is clear and unambiguous.
The Commonwealth agrees with the motion, right?
Yes.
Why didn't you come to a single justice after it was denied in the trial court?
Sorry, what was the question, Judge?
Why didn't you ask the single justice to expand the record?
I did. I filed with the single justice, and they referred it to this panel. They said that the
Oh,
panel...
my apologies, okay.
Yes.
Sorry.
So I did do that.
Can I ask you, and by the way, even though I'm asking tough questions, I thought the briefs both were excellent, and I'll say that very helpful in understanding what the issues are. So I say that with this backdrop. But you, in your oral argument, keep referring to prejudicial error, and this was not objected to at trial, correct?
Right, but...
So how do you get to prejudicial error, I guess, is first question.
Well, a violation of due process is going to be error, and if a person is found in violation of a restraining order that they didn't have notice of the prohibited conduct, then that's going to be prejudicial because they're going to be convicted of a crime.
So you're suggesting our standard for review for an unobjected to, something not objected to is not substantial risk of miscarriage of justice?
I am not suggesting that, Judge. It is substantial risk.
Okay, I
Yes.
just want to make sure that I
Yes,
understand.
my apologies. Yes.
Do I read your brief right that you have about 5 different ways in which you argue that this conviction needs to be reversed? One of them being is that there was insufficient evidence presented that if you read the restraining order to prohibit 5 feet from the plaintiff, that the Commonwealth failed to establish that the defendant was 5 feet from the plaintiff, period, you win.
Correct. And I think either way I win. I think if the court doesn't expand the record and make that finding that the modification required Mr. Marcelin to stay 5 feet from the plaintiff and not his mother's unit, then I think there's the ambiguity, and I think we win if we go that route. And I think that if the court does expand the record and allows the transcript of the modification, I think that is clear, where the judge is saying 5 feet from you, meaning the plaintiff, his mother. And I think that in terms of insufficiency, I think that with the expansion, I do think that what I'm arguing is insufficient based on the modified order, which is clear and unambiguous and does clearly state from the plaintiff, 5 feet from the plaintiff in the unit. And from the ambiguity argument, I would say first step is the court would, I believe, have a basis in the law to find that this order was ambiguous. and should have been resolved in favor of Mr. Marcelin. And in the event that the court then takes that step to resolve it in his favor, then there is insufficient evidence, because in his favor means 5 feet from the plaintiff.
So I appreciate the Commonwealth's position in their brief that says really no objection to expanding and including that as a record. I very much do so. But I also appreciate the fact that they say, and when you read this record, it supports our argument, because it supports that the judge was just trying to get at not unhousing or keeping an individual unhoused. And I understand the rule of lenity and ambiguity, but that what the judge indicated at that in the transcript is, you can live on the first floor. She's up on the second floor. You see her. But there was some language in that transcript that said, as long as you're staying in your place and you're not harassing and you're not contacting, it should work. If not, come back to me, right? I mean, so what do you say in response to the Commonwealth's argument is that, sure, take the transcript. It supports our position that he knew, the reasonable person would know in common understanding, to stay 5 feet away from the unit.
Sure, I think that the Commonwealth takes that statement out of context, or not completely with the paragraph before, which I think it has to be read in conjunction with. So although the judge does acknowledge, he does use that language that Mr. Marcelin live in the unit, he also contemplates incidental contact. And we know from case law that incidental contact, when a defendant is exercising his rights that are permitted under a restraining order, is not a violation of a restraining order, and that's Commonwealth versus Silva. So I would suggest that the whole purpose is to get him back into the house so that he's not unhoused, so that he can live there. If he's required to literally stay in his unit, he's not able to exercise the rights that the judge wanted him to be able to exercise. In a multifamily unit, common sense dictates you have to be able to move in and out of the common areas.
If that's what the judge wanted, though, why then the judge had the option to vacate number 3? Amend number 2 to say no contact when in the apartment 5 feet, on the outside world 50, right? But vacate. But the judge didn't vacate number 3. He modified it, right?
That's correct, because
in essence, your interpretation is really just it results in number 3 having no force and effect. It's really modifying number 2, which is stay away from mom 5 feet when you're at that location and 50 feet when you're outside the door of the home.
Well, I would actually push back on that,
Okay.
Your Honor. I think that number 3, the purpose of the force of the modification was to allow him back into the home. And if you're not going to allow him to use the home, there's all kinds of reasons why you need to be in common areas of a multifamily unit, electrical boxes, HVAC, storage. So he was permitted, I would suggest the court wanted him to be able to use the multifamily home to not be homeless, while still obviously balancing the rights of the protected party. That's sort of the...
But what effect does number 3 have once it's modified? In other words, the judge, in essence, vacated number 3, didn't?
No, the judge modified the purpose. I think he was balancing the interests of Mr. Marcelin. That's the purpose of the modification, was to allow him back into the home and have use of the home while still making sure that the plaintiff was protected and her interests were protected. And
would she be equally protected had the judge vacated provision number 3?
That's a good question, Your Honor. I guess that he, I think if you look at the actual language, he did vacate number 3 by modifying, or he modified it. So he changed it, but it's still related to Mr. Marcelin's ability to go to the multifamily unit?
That's a great question. Justice Walsh asked, because I'm reading number 3, and it says, "You are ordered to immediately leave and stay away from the plaintiff's residence," and then it goes on from there. And then the judge says, number 3, modified, not vacated or anything like that, just modified, defendant may live in first floor apartment. And then at the end, in brackets, the judge emphasized 2-family residence. So now I can kind of see why the jury would have come back with a guilty based on that if they were reading it that way, that it was not, that number 3 was not vacated, it was just modified.
Well, it changed his ability to go to the house and to use it. Yes, he didn't have to stay away from the multifamily unit as a whole.
Oh, no, yeah, but if that language is still in effect, he does. You are ordered to immediately leave and stay away from the plaintiff's residence.
That's the original order, that's the...
Correct,
Yes.
which wasn't vacated. It was modified. So is that language still alive, that first line? If it's still alive, then, like I said, I can see why a jury would say guilty.
Well, I think that I don't see how it could be read by a person of common intelligence to still be alive where it says number 3, modified, defendant may live in the first floor unit.
Right, but that doesn't affect what the judge said about access to the plaintiff's residence. So he can have access to his residence, but he still has to stay away from the plaintiff's residence.
Well, I think what the judge was struggling with is that Mr. Marcelin's residence and the plaintiff's residence were one and the same. It was a multifamily unit, and I would just, again, I see that I have 30 seconds left. The fact that this court, 3 very, very intelligent, experienced attorneys and justices, the fact that you're struggling with how to interpret this, I would suggest, again, support the ultimate argument, which is that this modified order was at best ambiguous, and that it would be a violation of due process to find Mr. Marcelin in violation of this order where he was not sufficiently notified of the prohibited conduct.
I have just one small housekeeping matter. In your opening brief and your reply brief, you rely on dissenting opinions in support of your argument. And outside the realm of asking for a change in the law, as proud as Justice Milkey is of his dissenting opinions, they're not precedent, and they're not helpful.
I will take that into consideration.
They're not helpful to your argument.
Oh,
They're not precedent.
understood, Judge.
Plus the reasons you cite them for can be found in a bazillion other cases.
Well, I believe that Carino is the only case that discusses the rule of lenity as it applies to restraining orders. There are obviously a number of cases that talk about other court orders like conditions of probation.
You just don't want to be caught not making an appellate argument.
I appreciate that.
Thank you.
Thank you.
Mr. Marshall.
Good morning, and may it please the Court, Charles Marshall on behalf of the Commonwealth, the appellee in this matter. We're asking that the Court affirm the defendant's convictions because contrary to his contentions, the order as it existed after the July 29th modification still did require the defendant to stay away from the victim's upstairs unit, that being Unit 617. There was sufficient evidence produced at trial to prove that he violated that condition specifically. And lastly, the jury was the correct party to make that determination. So starting where Justice Walsh and Justice Hodgens focused most of my sister counsel's argument, the due process claim. So I think it is clear from a few things that this was a modification, not a termination, and I think that's the most determinative question here. And that's clear from, first, the plain language of the modification itself. If you look at what is written on the order, it states that number 3 modified, number 3 being the stay away from the victim's residence, and modified that they may live in the first floor unit, must stay away, have no contact with the plaintiff, 5 feet away when living in the unit, and outside must be 50 feet. The way I read that, and I think the most reasonable way to read that, is it is functionally a termination of the leaving of the residence, but all of those explicit conditions that they outlay after the modification is more so helping guide his conduct when he is living in his apartment and not so much vacating the stay away from 617.
Can I just interrupt for a moment? Because I get your point, okay? And I think it's your best argument. But having filled out many of these forms, in some ways, it's a little bit unfair because it's a form problem. You get this teeny little box that says modification/extension. And the only way to vacate portions of restraining orders, you can vacate the whole thing at the very bottom, all right, is by using a box entitled modification extension, not vacate, and then use some language that says what you mean, right? And here, when you look at this, which actually, one could argue that it's not ambiguous. And it's clear, stay 5 feet away from her, from mom. And then you look at the transcript, which again, I appreciate that you don't quarrel with us looking at the record, which is refreshing. The judge doesn't say, you better stay away from that apartment. You better stay away from mom's house. He says, you don't contact her. You see her, you better go the other way, right? You're in the front, she's in the back, you get out of the way. You don't text, you don't have your sister, you don't have your father, nobody's to contact her. And when outside it's 50. What you're saying, I understand, but what the defendant heard and what the defendant was told is something different, isn't it?
So I would say that it's not necessarily different. If Your Honor's point is that this form itself is not perfect, I would agree with that. It's part of the reason why I have no problem with this court looking at the record of the modification hearing itself. The other reason being the one that you pointed out selfishly, I do think that it helps the Commonwealth's contention. However—
How so, though? Because it doesn't say, Mr. Marcelin, even though I'm letting you live at your old place, don't you dare step foot into your mother's apartment.
So I also agree with Your Honor, and I believe this is the point you're making, is that the actual finding, the modification itself, written and orally, isn't as clear as it possibly could have been. What I'm saying is that that's not the standard, essentially. As you noted earlier, the standard for 209A orders, it requires a clarity of expression with the purpose of giving a person of ordinary intelligence a reasonable opportunity to know what the order prohibited. I believe this does, and we sort of have somewhat of a control group that shows us what other reasonable people believed and took this order to mean. The first two, as we noted, being the two trial attorneys who both in their openings and closings and throughout the trial put forth to the jury an interpretation that this was a stay away still from the residence, albeit a 5 feet from the residence. We can also infer from the victim's testimony—
Can I back up there? Where did they get the 5 feet from the residence from? I know you say this is a common understanding. Where is the interpretation 5 feet from residence? I don't see that at all.
So I will say to Your Honor, my interpretation is not the same as put forth at the trial. My interpretation of the order itself is that the stay away from the apartment was not limited to a certain amount of feet, but to just essentially the definition from the case law. And the case law makes clear that there doesn't need to be a specific delineation of feet. However, I don't think that interpretation, the 5 feet from the door, was unreasonable for either of those attorneys to interpret it that way. And I will
So if they were separated by, if they were within 5 feet of each other but separated by a wall, would that be a violation?
I struggle to see a situation where that would happen just based on the testimony about the dynamics of the house itself, or how necessarily that would be proved.
Or if he's to stay 5 feet away from the residence, whether she's there or not, I think everyone agrees. He always has to stay 5 feet away from doors and walls that are near her residence?
So I wouldn't interpret the order that way. I don't think that's a reasonable interpretation, but I think a reasonable interpretation of the modified order is that the modification didn't permit him to go up the stairs, and there was testimony that those stairs led directly to a back door of her apartment. His apartment was on the first floor. There was really no reason for him to be up those stairs. There was no reason put forth at trial and a case by the defendant about why he was going up those stairs. No, it is not a reasonable interpretation of the modified order that he could just freely walk up those stairs, place himself right outside the door that leads directly into her apartment.
But he's not within 5 feet of her on those stairs, right?
No, there was no testimony either that she was there or wasn't there put forth at trial, so I have to assume.
Don't we have to look at the larger picture here of the reason for the modification is that this fellow was rendered homeless by the original order?
I do, Your Honor. I think we should take it all in context.
He modified it that affected what had previously been stay away from the residence. So now you have to stay away from her. Inside, can't come within 5 feet. Outside, 50 feet. So they're focusing on the victim, not the residents anymore.
So I agree that we need to view it in context, but I disagree that that is necessarily the takeaway. The point of the modification was essentially it had been revealed to the court during this modification hearing that from the date of the issuance of the temporary order to the date of the modification hearing, that Mr. Marcelin had been rendered unhoused. He had essentially been homeless for those, I believe it was 9 days. So the purpose of the modification was essentially explicitly just to allow him to move back into his unit on the first floor. All of that language in the written order then after helps guide his conduct while he is now being allowed to live in that first floor. It does not terminate the stay away from the upstairs unit. And I think that's clear in both the written order and in the oral finding of the judge during the hearing. And I think what is important is nothing about the language in the order, about the 5 feet from mom when he's on the apartment, none of that conflicts with the stay away from the upstairs unit. They can still be read harmoniously. Where I would say that essentially that modification had the effect of terminating the leaving the residence, the vacating the residence, because they cannot be read harmoniously. A stay away from the mom 5 feet while you're on the property, if you see her avoiding incidental conduct, if you can, that can still be read harmoniously with the stay away from the upstairs unit. And I liken this because I think it's the most case on point, the Stewart case, which I cite explicitly. In the Stewart case, there was a modified version of an order that required the defendant who had shared custody with the plaintiff's children to remain in his car vehicle at all times during pickup and drop-off of children. That was a modification of a stay away and a no contact. And there the court or the defendant argued essentially that he argued against the meaning of the provision and argued that the instructions improperly characterized what was prohibited under the condition, akin to what the defendant argues here. And the holding essentially was that that modification merely lessened to some degree the restrictions on the defendant's orders, but kept in place the orders themselves and had the effect of forming what they refer to as a protective bubble to the defendant's benefit, where that car served as a protective bubble. So long as he stayed in that bubble, he was removed from criminal liability for what orders were still in place. And it is when he left that protective bubble that he opened himself up to criminal liability. Here, I would suggest that the purpose of the order and what was clear by the modified order was to create a protective bubble in 615 so that he could get off the streets, move back into his apartment. And when he left that protective bubble by going upstairs to the upstairs apartment, the victim's apartment, for no reason, putting himself mere feet from the door, he opened himself up to criminal liability and thus violated the stay away.
So this is mom upstairs, son downstairs.
Yes.
Son learns with this modified restraining order that mom went to Florida for 3 weeks. And sis says, come upstairs, I just baked some bread, right? So mom is not home. He goes upstairs to 617, gets the bread, comes back downstairs. He's guilty of violating this restraining order?
I would say yes, Your Honor.
Because your interpretation is that paragraph 3 still was in effect. And I have to say, if what's fair and required for due process is clarity, this seems to be anything but.
So I would say, I would say just to your point about going upstairs being a violation, the case law makes clear that the person's presence in the apartment in terms of a stay away does not matter.
I oppose that too, wasn't it? Right.
And also just getting to the sheer purpose of 209A orders, there's case law that also says that we don't want that purpose to be frustrated by a person essentially keeping track of an individual's schedules and their whereabouts so as to go up when the people are not here. That's kind of the crux of the rule. And also the purpose of 209A orders being to provide a safe haven.
No,
in
but
which,
the bubble is for the victim's residence. The bubble is not supposed to be for the defendant's residence. And your legal argument is that number 3 was still in full force and effect. That's what was argued at trial. That's what everybody understood it. But I have to tell you, counsel, when I look at the modification, that seems to me, at least, to be an uphill battle, that this was clear enough for the ordinary person to understand. When if it said 5 feet away from unit, it says no contact with dash 5 feet away from plaintiff. No contact with plaintiff 5 feet away when living in the unit, outside of unit 50 feet away. All in one, right?
So I don't mean to sound like a broken record, but I think the most determinative part of that order is the fact that it says modified at the start and not vacated. And whereas all of those additional, or I wouldn't call them additional, but it's essentially delineated conditions about the 5 feet and 50 feet, none of them frustrate the stay away. They can be read harmoniously, and where they can be read harmoniously and where basically the argument of the defendant is that it is a vacation because it would render number 3 meaningless if it was, in fact, a termination. It would also frustrate the purpose of creating a safe haven for the victim. If this is, he can go up so long as she's not there without violating the order, I would suggest that that was not the purpose of the modifying judge. It would frustrate the purpose of 209A orders in general, and it is clear enough that a reasonable person should have understood it that way. And aside from, as I mentioned, the 2 trial attorneys interpreting that way, it can be inferred that the victim, mom, also interpreted it the same way, given the fact that when she saw this video of the defendant outside of her house, she interpreted that as a violation. That's why she reported it to the police. So essentially everybody involved, the 2 trial attorneys and another party who was at that hearing, interpreted it the same way. He is not, the modification did not give him free range to just go up to the apartment whenever he pleased for no reason, so long as she was not there.
I know you disagree, but if we were to find that the restraining order prohibited him from 5 feet contact with mom, plaintiff, do you agree that there is insufficient evidence at trial?
I do. If this court reads it essentially just as a no contact order, there's no violation. However, I do think, and I see my time is running out, I do think that given the fact that this was never challenged via a motion to suppress under due process, it was never flagged for the trial judge, it was never, the instructions themselves weren't objected to. Both the defense attorney put forward that this was a stay away from the location, and under the Lattimore standard, I think the jury was the appropriate person to interpret the order themselves, and clearly they interpreted it as a stay away, and I think that's indicated by their questions too. They were never not considering this as a stay away.
Thank you. Thank you both. Excuse me. Thank you both. We'll take it on advisement. We're going to take a brief recess.
Hold on, please. Court is now in session. Please be seated.
Our next case is 24P207, FISAK versus FISAC. Mr. Barak.
Thank you, Justice Meade. Good morning. May it please the Court. Matthew Barak for Joel FISAK, the appellant. The appellant respectfully moves this honorable court to vacate and remand the judgment issued by the lower court, and to order the lower court to enter an order for sale of the former marital home and to determine an appropriate amount of child support and alimony, if any. Here, the lower court abused its discretion by not equitably dividing the parties' assets consistent with the application of 20834, by unreasonably delaying the sale of the parties' only major asset, the former marital home, for a period of potentially 19 years. Second, and critically, the lower court committed clear error by improperly conducting the required three-step analysis of Kavanaugh and Kavanaugh as described by the SJC in the first Kavanaugh case, when there is child support and alimony present, which there was here. In Kavanaugh 2, which came out at the end of July of this year, quite recently, the court specifically stated, the trial court judge erred in step one by considering the availability of child support when evaluating the mother's needs for alimony. They go on to write, the SJC specifically rejected this approach, stating it makes little sense to tie the availability of alimony to the provision of child support, where child support and alimony serve distinct purposes.
You say that a payment towards the marital home is alimony.
I did.
Yeah.
It is.
And you cite Section 48 of 208, but that section doesn't say that, though.
Well,
is there a case that says that?
I think I'd refer us to the definition of the alimony statute, which is the payment of support from one who has the ability to pay to a recipient, one who has the need. That's precisely what happened in this case. The judge wrongfully, under the Kavanaugh framework, excluded alimony by stating that there would be no income left once you run the child support analysis. Kavanaugh 2 says that you cannot do that. So right there, the analysis is wrong.
If we were to approve the sale of the house, is your client okay with paying child support and alimony?
Of course, because he'd be paying, potentially, he could, in the short term, might be paying a drop more, maybe paying the same if it's evaluated correctly and there's a proper income attribution as there should have been here.
Your big concern is that theoretically, depending on if the youngest goes to college or not, that from the time of trial, they have to wait 19 years to sell the house.
100%. And I don't think I've ever seen a case that allows that.
That was my next question.
I couldn't find a case. And in fact, each case is completely distinct from these set of circumstances, where in the past they've allowed for such a delay of sale. There's never been
under the alimony
for 2 decades.
And the Alimony Reform Act puts durational limits.
Durational limits on it, correct.
Based on how long the marriage.
Correct. Which would have been 13 years here.
And the math is 13 years for this one.
Yes, that's right.
But let me make sure I understand the argument, because when I read the judge's decision, I read it to say 0 alimony, everything is child support in best interest of the children. And so because of the unusual set of circumstances and the facts, well, first of all, you'd agree with me that the judge has the authority to delay the sale of the home.
Under a limited, measured, and reasonable basis, but not, let me finish, if I may, not to tie it to the child support in light of the provisions in Kavanaugh.
So I understand your argument about abuse of discretion, that this is too long, too far, too much, too burdensome. That I hear it. I've never seen something like this either. I have not either found a case that is so broad far-reaching. However, I don't know that Kavanaugh gets you there. So if we accept that this is pure child support, your argument still is that it's an abuse of discretion.
Yes. So I'll take that up backwards. So I'll take it your second point.
I mean,
Your second point. So
Could be wrong, but-
for child support,
Right.
there's a big problem here too, because what the judge says is that she didn't deviate from the child support guidelines. Well, how does one not deviate when they reduce the child support in half? I don't understand that. There's a great ambiguity there in the judgment that I think cannot stand. She literally, in her judgment, said she's not deviating. But the reality is she did deviate because she reduced the amount of child support. Secondly, when we read the child support guidelines, there's nothing in the child support guidelines that suggests the payment of the former marital home can be considered a reduction. Certainly, yes, it can be in the best interest, but it's not one of the stated reasons to deviate. So here we have a deviation when the judge inconsistently is saying, I didn't deviate. So I'm not sure how we reconcile that with the provisions of the child support guidelines. And that's why I put it back to you that I think if it looks like a duck and it quacks like a duck and walks like it's a duck, it's alimony. That's what this is.
How is husband employed now?
He is, I think, doing the same stuff he was doing before, although he had gotten a job by the time this kicked around. I wasn't his trial counsel, I'm just his appellant counsel, but he had gotten a job by the time trial was in. So I think he is still gainfully employed at the present time, to my knowledge.
I'm just wondering if part of the answer might lie in Section 34, Chapter 208. As I read it, it says, in fixing the nature and value of the property. So it seems to me that the statute contemplates that the judge is supposed to be, as it says, fixing the value of the property at a given point in time, and that by delaying a transfer of the property for some indefinite period, that value is not being fixed. Does that make sense?
Yeah, I agree with that. I think that the Duant case is sort of on point here too. We didn't cite in our brief, but I'd call the court's attention to it in that when we value assets that are liquid, they should be divided at the time of divorce. So I think she's not done that here. In the other cases where they've allowed for a delay of sale, it's measured reasonable 2 years. One time there was another 8-year thing, delay after a modification action. The initial judgment was only 2 years. But in those cases, we didn't have one party paying the freight of the house that they were no longer living in, one. And two, in those cases, the other party was granted the property in the meantime, which didn't happen here. So to your point, she's delayed inequitably the division of the assets. I mean, the whole point of divorce is closure. We need finality. There's no finality here. These folks are now tied to this house for potentially upwards of 2 decades. And then you raise the point, well, what happens?
They're tied to their 3 children, too.
True. They're tied with them, too. But people don't want to be, they want to get rid of their assets, and as you know, and move on with their lives financially. Here, we had children, one who I think is now 18, I think the other child's about to be 16. If she had delayed it till, a couple of years, that might be, I don't agree with the Kavanaugh analysis. I think that's still an error. I'm not going to concede that. But that might have been a reasonable measured approach to say, okay, we'll wait till the sophomore in high school graduates and the property will be sold in 2 years. But when you have a 3-year-old, 4-year-old, I think a 4-year-old at the time of trial, there's no compelling reason here. The other thing is, in the cases where the court has allowed such a significant delay, it's been cases where there's been evidence of psychological damage to the children. There's psychiatrists that have testified in the facts that support, really strong, specific grounds, mental health reasons or psychological reasons or whatnot, to support a delay of sale. There was nothing here. Here, it was found that the parties were in good health, the kids were good, things had calmed down in terms of the custodial stuff at the time of trial. There's a shared legal custody component here. And also, I'd point out, I don't think that the mother here was even seeking what the court entered. She said that she'd be okay with a buyout when you read the testimony.
What about the judge's finding, it was number 50, where she said that the youngest child would likely have a very difficult time if the mother was forced to leave the marital home? What do we do with that?
I don't agree with it. I don't think it was based on any evidence. I think it was conjecture to justify delaying the sale of the house without specific evidence. I mean, I think when you read the evidence as a whole and you coalesce it, and you compare it to the case law where there have been delays, you just don't have that kind of significant events that would enable a judge, without abusing her discretion, and to allow such a delay of sale. And the other thing too, this is a court of equity. I mean, people come to get divorced, the court of fairness, the probate court. And I think it's just an incredible unfair judgment to tie these people together for so long. And both of them too, because I don't think mom was actually seeking this result. Whereas, this is their only asset of the parties too. I mean, this was it pretty much at that point in the trial, was the house. If I have nothing further,
okay.
I would submit on our papers and ask you to reverse and remand the judgment.
Thank you. We'll take it under advisement.
Thank you.
The next case is 24P 1464, Department of Children and Families and another versus father and another. This, as you all well know, is impounded. So please refrain from using names. You can use titles or other descriptive terms. Mr. Young.
Thank you. May it please the court. My name is Robert Young, and I'm here on behalf of the father. The father is asking this court to vacate the termination decree because the constellation of factors identified by the judge to support the unfitness finding are flawed and not clearly and convincingly demonstrative of grievous shortcomings at the end of trial. And I identified in the brief what I would refer to as 5 of those factors. The one I'd like to focus on primarily is the way the judge addresses, for lack of a better term, the child's needs and the father's ability to meet those needs. The judge finds that the father never provided care for his son, that he didn't understand his son's needs, and he could not meet those needs. Those 3 findings and conclusions are erroneous, because the father, through his own interactions with his son during the life of this case, as well as his testimony, demonstrated that he understood his son's medical and behavioral needs, as well as his, as he characterized it, fear of abandonment and loss of family. So on that first point, as far as being a caregiver for his son, the father did provide primary care to his son roughly in 2008 when he was living with the mother and his son. The judge made a finding that they resided together during this period, and at record page 372, which is Exhibit 27, I cite to this in my brief, but I did want to mention it again, that the social worker notes in 2021 that she was aware that the father was providing care to his son when living with the mother, and there was a notable difference when the mother was left to her own devices to care for the child. The child was doing much better when the father was present. So the father clearly had a bond with the son. There was no disputing that. The judge made that finding. The department recognized, certainly in their observations and visits, that the father and son were closely bonded. The father was observant and very mindful of his son's safety. He modeled empathy and actively engaged with him. They had fun together during these visits. Yet the judge draws a conclusion that the father was unable to control his son's behavior during the visits, and that's an erroneous conclusion. There was one incident involving a tantrum over some shoes. The father gave in and provided those shoes to his son. Otherwise, in fact, the judge in conclusion 18 notes that most visits went well and that they maintained a bond. So the father's connection with the son was clear. As far as his understanding of his medical needs, he testified, and I note this in my brief, that there is a pretty close correlation to how he describes in his own words his son's needs from having been born substance exposed, and to the way that the department, the adoption worker, and the judge described those needs. He identified the breathing issues. He identified his son's need for medication, his behavioral issues as far as difficulty sitting still, his short attention span.
There seemed to be some deficit in the father's knowledge of the child's medications.
Well, I think, as I say all of this, I think what's important to keep in mind is he really wasn't able to attend the medical visits, right? And the judge faults him for that. Now, this is a father who was living in Springfield and couldn't get to the Boston medical appointments. He made one effort. It was the wrong date. So I find it fairly remarkable that what he was able to articulate at trial was so close to what the adoption worker who had access to the medical information and what the judge heard as far as the evidence. There is not a lot of daylight between the father's understanding. Now, medication, sure, this is a guy who taught himself to read during the life of this case. We're using an app that he got for his son. Would I expect him to be able to go into medical detail? No. I mean, he used his own words referring to the endocrinologist as the hormone doctor, but he knew there was a doctor that was dealing with that with his son. He spoke, going to this idea that he provided care to his son. He knew what kind of condition his son was in as a newborn. He said, as a newborn, he's always been a little behind on weight and height. Seeing the hormone doctor, like I mentioned, he had ear infections, fluid in his lungs, asthma. He also recognized his son would need an IEP, most likely, as he was entering school. He also had a plan for how to meet those medical needs. He submitted a list with the assistance of his wife to the department that my sense of this is it tallied all of the doctors he would need to switch to at Bay State in Springfield. So he had a plan for that. And that solves the issue where the judge made a conclusion that, which is likewise erroneous, that the father would remain unable to get to those medical appointments. And that's in conclusion 13. I think that's moot once they are all in Springfield and his providers are there. Likewise, certainly a child has some complex medical and behavioral needs that need to be addressed, but even the department acknowledged he was only seeing a pulmonologist maybe twice a year. He was seeing other specialists quarterly or on an as-needed basis. So I don't think there was anything extraordinary. These weren't weekly or monthly visits to Boston for medical
Yeah, but didn't DCF indicate a willingness to accommodate the transportation difficulties that the father was having, and He just didn't avail himself of that?
Yeah, so trial started in September of 2022. It was January of 2023, after some complaining from father and his attorney, that they made an offer of bus vouchers to attend appointments. And it's not clear to me in the record if there were any appointments after that that he could have attended. There were obviously visits before, medical appointments before that he didn't attend. But it was a little too late as far as that goes. And like I said earlier, even without that, he was able to, I think, accurately describe his son's needs and express an intention to continue that care, but just in a location more convenient to himself. And then just on that last point, as far as visits and as far as the parent-child visits, the judge makes another clearly erroneous finding that the father willfully failed to visit. The visits started in late December 2020, and trial concluded in August of 2023. And now I did a little back of the napkin calculating as far as, first he was doing weekly visits, and then bi-weekly visits for roughly that last year. That's over 130, it's at least 100 visits potentially. And the judge, if you add up, says there were about 20 visits missed. And those were not all the father's responsibility. Some were DCF canceling, or foster parent canceling, or illness. There were some that he failed to confirm, which the department puts the onus on the parent to confirm. So willful is absolutely erroneous. The father was needing to travel an hour at first each way from Springfield to Athol with a suspended license. He had to strategize on how to get there. He made it to the majority of the visits. And like I said earlier, the observations of those visits were as the judge says, most visits went well. In the time I have left, there are 4 other factors, and I'd like to just briefly address those. The second factor, I think, that is...
just before you get there, did you say, I thought you indicated there were 3 clearly erroneous findings, and I got the...
Correct.
Not understanding meeting child needs, the willfully failed to visit. What was the third one?
So, that number 1 under this factor, I was saying that he never provided care for his son, and that is clearly erroneous based on the judge's own finding that he lived with the mother during a period in 2018, as well as that email that's reproduced in Exhibit 27 at page 372, the social worker email who notes that the child's care was better when the father was present. And then the second would be not understanding his son's needs, and third, that he couldn't meet those needs. And I would just steer you, Justice Hodgens, you to conclusions 3, 7, and 13. It's woven throughout those conclusions. So as far as what I would characterize the second factor is this idea, there was certainly a disturbing domestic violence history that the father overcame, and the judge credited him with that. That the last incident, which was really a Facebook contact violation, occurred in 2020. But the judge proceeds to make some conclusions that the father demonstrates is unable to control parental traits of his character and conduct. And that at one visit in April of 2021, when he got upset at DCF at the start of a visit, that represented his violence of temper. Well, the last entry on his criminal record was in March of 2022 for an assault charge regarding an incident with a tow truck driver that he pled guilty to and received a 3-month suspended sentence. That's the last entry. A year and a half later, trial concluded. And in that year and a half, which often can be...
Right, so that incident happened while the trial was underway, is that right?
No.
Did not?
That happened 6 months before trial started.
6 months before, okay.
That was March 2022. And his suspended sentence expired before trial began even. There was an April 2022 argument with DCF where they, at the start of a visit, started to question him about what had happened with the tow truck driver. And he got upset at them because he was there for his visit. But the judge, without anything in the record after, for a year and a half, the judge concludes the father's unparental traits and this violence. And that's just clearly erroneous. The remaining three factors I do address in detail in my brief: the substance use, father's mental health treatment and diagnoses, and the housing. Substance use, the judge concludes the father's misusing his prescribed meds and oxycodone, and that he's misusing unprescribed substances. And yet the father, there's nothing to indicate that the department ever asked the father to be drug tested or ever asked him to participate in a substance abuse evaluation. And
But didn't the father admit to lying about a tooth?
right. So yes. Well, yeah, he certainly did. In fact, there's a theme here that he's often been very forthcoming about his circumstances, which is unusual for a parent with some of the concerns that have been raised. He admitted later he was afraid of the department, so he lied about that. That oxycodone bottle that was observed was back in, I believe it was in April, it was in the summer of 2021, okay? The department had on the service plan for the father to submit to drug screening if requested. There's nothing to indicate it was ever requested until June of 2023 at trial, when the court made available a screen. And the father, again, in honesty, said it would be positive for THC, and that's the only result on that screen. And yet, the judge makes these erroneous conclusions that he's abusing prescription meds.
No, my
oxycodone.
suggestion is that how could that be erroneous when the father himself admittedly appreciate?
Well, we're talking about
honesty.
current fitness. So 2.5 years later.
Okay, so staleness versus erroneous because it didn't happen.
Well, he does draw the conclusion in conclusion 5 that that's going to continue undiminished, that will continue into the future. And there's nothing to indicate it would continue into the future. And seeing I'm almost up my time, I'll rest unless there's any further questions.
Seeing none,
I'll
thank
rest
you.
on my brief. Thank you.
Ms. Pizzoli.
May it please the court, my name is Carol Frizzoli, and I represent the Department of Children and Families. In a careful and thorough decision, the trial court, while acknowledging father's personal gains, given this child's special needs, found that father's improvements were not enough, and father could not meet the significant needs of this child. At the end of trial, this child was 5 years and 8 months and had been in the department's custody for more than half his life. The trial court properly found it was in the best interest of the child to terminate father's parental rights. The trial court properly considered father's history of mental health issues, ongoing criminal activity, domestic violence, and substance abuse in conjunction with his limited engagement in services and failure to make observable changes to have a prognostic value in measuring child's unfitness. The trial court considered a multitude of factors in determining father's current unfitness. With respect to his mental health, what the trial court found was that father didn't recognize the symptoms of his diagnosis. For example, he denied had been diagnosed with schizophrenia, bipolar, but he denied that he didn't recognize his own symptoms. In one hand, he'd tell the social worker he didn't want to be around people and didn't want people at the house. His own behaviors, he didn't recognize. He said he didn't have schizophrenia, but he did have a friend named John since he was age 14. He told the social worker and actually testified at trial that he had a prescriber for his medications for 4 years and didn't know the name of the prescriber who was prescribing him. In addition to, he couldn't even, throughout with respect to the findings, there's much evidence that he couldn't control his own medications. When the social worker would come to the house and say, "Can I see your medications?" he'd be, "Oh, they're at my mother's, they're at my brother's." He would keep them in an entertainment center. Again, couldn't even manage, when he had a parent helper, that were all clear that the father himself couldn't manage his own medications, which was measured in what he would have to do for his child to be the caretaker.
That was anticipating my question. So what's the nexus between those deficiencies and his ability to parent this child?
Again, this is a child, as we've all said, who has special needs. I mean, the child sees a pulmonologist, an endocrinologist, a gastroenterologist, has nutritional issues, also has behavioral issues, sees a psychiatrist, and other caretakers. This father couldn't manage his own medications, never mind be responsible for attending to the needs of this child who had both medical and emotional and behavioral needs. This was not, as stated, that there's the nexus, that's what the trial court properly found, that he couldn't manage his own health, never mind trying to take over the health of a young 5.5-year-old child who has all these special needs. So in addition to his own mental health, what brought this case into care was the domestic violence. Now, again, I think the appellant's attorney just stated that the father had been a caretaker of this child for 1 year. However, when the child was born at 26 weeks, there was an incident at the NICU where he went to the Ronald McDonald's house where the mother was staying, where I believe the parents were staying, and he beat the mother up over a PlayStation. I mean, while the child was in the NICU. That was one of the first incidents of documented domestic violence between these two, which resulted in a restraining order. And even in violation of the restraining order, the father admitted at trial that he said he was, he was living with the mother. But again, we get back to there was no erroneous finding of the trial court that he was never the primary caretaker of this child. And the violence continued between this couple. The father, one of the reasons, there was a restraining order that was issued that resulted from a dangerousness hearing where the father went up to the apartment and admittedly choked the mother and said he used the floor as a weapon. That's one of the incidents that brought this child into state custody. So again, the father should be commended. He did attend this Proteus program, but that was a condition of his probation, which he testified that the only reason he attended this program was it was a condition of his probation. So although the trial court credited the father attended that program as well as a Nurturing Father program, he didn't make observable changes. And that is evident by the incident, 6 months prior to trial. The trial court properly credited the father. There were no domestic incidents since 2020. However, that right 6 months before trial, the father gets in an altercation with a tow truck driver where he's charged with assault and battery. And then when the social worker goes to ask about it 4 months before trial, he explodes at a visit where he had to be redirected. So again, that anger that channeled, that brought this case into the reason that we have this case was demonstrated by his behavior at the tow truck driver. So again, the trial court properly considered all of these issues in addition to his substance abuse issue and his failure to make the child a priority. His visitation consistency wasn't consistent. Even 3 months right before trial, the father chose not to visit this child. Given the limited participation in services and the special needs of this child, the trial court properly found that although the father made some gains, it just wasn't enough for this particular child. So we would ask that the trial court's decision be affirmed, and I would rest on my brief.
Thank you. Ms. Altamore.
Good morning, Your Honors. May it please the Court, my name is Joan Altamore, and I represent the child in this matter. It's a young boy, and we argue that the decision of the Court to terminate father's parental rights was reasonable and appropriate. By his actions, father has failed to make observable changes that would ensure the safety and well-being of this child. As noted by my sister counsel, this case opened because of an issue of domestic violence between the mother and the father. That caused father to become incarcerated and then not be able to visit with the child until December of 2020. The case was opened by the department, I believe it was in 2018. So there's a period of approximately 2 years where he did not visit. Bringing into account my brother counsel about the visitation. It's true that approximately 20 visits did not happen, but those 20 visits were within the scope of approximately, I believe, I have it here, approximately a 1.5 year period. In March of 2022, he missed 5 consecutive visits. In September and October of 2022, he missed 9. Between November of 2022 and August of 2023, he missed 6. Those are the 20 missed visits. Trial started, the CMP actually was filed in January of 2020. Father didn't start his visits until December of 2020. The issue of visitation is also significant to note, and I had mentioned in my brief. Father missed one of those visits in October because instead of attending a visit, he didn't even call to cancel. He got married. He got married to a woman in the middle of the week, and during the course of trial, where he was on the witness stand, approximately like 2 weeks before, he testified that he was not in a relationship with anybody. 2 weeks later, he gets married to a woman that he states that he testified to that he was involved with for a period of 15 years. By the end of trial, that woman had never met the child. This is the woman whose house this child, father alleges, would be moving into. But for a period over a year, this woman did not make herself available to the department. Father did not make her available to the department. Father did not bring her to a visit, nor make the accommodations with DCF so that she could be brought to a visit. In terms of my brother's arguments about the recognition of the bond, there is a bond, and it was recognized by the judge in this case. The recognition is acknowledged, and the court ordered 4 post-termination visits per year. And so that does recognize that father and child should see each other and should maintain some contact. But that does not mean that father can be an appropriate caretaker for this child. In terms of the child has medical needs and the father has medical needs. At this point, at the time of trial, father was not able to identify with specificity the child's needs, what doctors he was seeing. There was testimony asking whether he had attended the medical appointments. Father had not attended the medical appointments. Yes, there were then accommodations made or about a bus ticket. None of that was taken, was done by father. But some of those medical appointments prior to that point in time had been virtual, and father did not attend those. The argument that the medical appointments were occurring in Boston and father lived in the Springfield area. Well, and so father would have a hard time getting to the visits. But father had access to a motor vehicle. In fact, father had access to a motor vehicle that he was driving without a license. There was testimony from the social worker that she observed father driving up to a visit behind the wheel of a car, even though his license had been suspended. Father could not identify, during the course of the trial, father could not identify his providers. the person who had been prescribing him medication, albeit for a period of approximately 4 years. He couldn't identify that person. In fact, father couldn't identify the outreach worker who brought him to court, who was standing outside or sitting outside in the courtroom. He couldn't identify that person by not even a first name, forget about a last name. So how is this person going to be in charge of multiple medical appointments, even if a medical appointment such as the pulmonologist would be once or twice a year, if father couldn't remember the person who brought him to court that day? The father, we argue that the father is unable to meet the child's emotional and physical needs. This is a child who was born at 26 weeks and had issues from birth. He continues to be unable to sleep well, has behavioral issues, has multiple medications, multiple medical appointments. Bringing those medical appointments closer to father does not take into account the other issues, such as sleeping well, behavioral issues, and actually giving the child the medications on a daily basis when, as father testified to, he had different methods of trying to keep track of his own medications. There was no meaningful effort by father to avail himself of services designed to assist or improve his lifestyle. Completing action plan tasks are important as it shows a dedication and willingness to learn, not just the classes, but the utilization of those learned skills into your daily life. Father took the Proteus course because he was required to by probation. However, after which was supposed to talk to you about anger management, how to control your emotions, and yet afterwards, father got into an altercation with a tow truck driver in a parking lot and was arrested and charged with assault and battery, and then accepted a plea. It's clear that there is a bond between this father and child such that post-termination visits are appropriate, but father is unfit to parent the child, and it is clear that his unfitness would last into the indefinite future such that the termination of his parental rights was appropriate. I have nothing further. I see my time is up, and if there are no other questions, I would conclude.
Seeing none, thank you. Thank you all.
Thank
Take
you.
it under advisement. Our last case is 24P976, Charles Taylor versus New Heights Builders. Mr. Vieira.
Good afternoon, and may it please the court. I'm attorney Kyle Vieira. I represent the appellant defendant, New Heights Builders of MA, LLC. There are two questions before this court. Question one is when a jury on a binding finding on a Chapter 93A claim finds that there has been an unfair and deceptive act committed, yet also finds that there is not a knowing and willful violation of Chapter 93A, can that 93A claim be predicated upon a non-disclosure of a material fact? And question two is the sufficiency of the evidence. Is there sufficient evidence in this record to support this 93A claim?
Did you move for a directed verdict on the sufficiency?
I moved for a directed verdict not on this issue. This issue came up with the verdict itself. I filed a Rule 59 motion to vacate on the basis that the law does not comport with the actual jury verdict. I contend that's an error of law, and it's either a new trial or vacate the judgment on that basis.
I guess I'm still unclear on the sufficiency argument.
The sufficiency argument arises because of the specific jury binding finding of not knowing and willful. Because the only liability here was on this 93A count. There was no contract found, no express warranty. So in the absence of those counts, liability on those counts, what could underlie that Chapter 93A claim? The course of conduct here is very limited. A few meetings between the builder and the homeowner, the plaintiff here. So the only logical claim that we could possibly see that could possibly underlie the 93A is a misrepresentation, more specifically a failure to disclose a material fact. So in the Underwood versus Risman and this is the Quinlan versus Clasby line. Non-disclosure of a material fact, for that to be a 93A claim, it has to be a knowing and willful violation. And the jury here specifically found no. The issue is...
Well, that's for treble damages, though, right?
Well, our position is that when a jury on a binding finding makes this finding and the case law requires the same finding, that should be allowed to be, we should be considering that as part of the case here. So because the jury, who was the fact finder...
But isn't the 93A count is complete when they determine it was unfair and deceptive?
I'm not sure I understand, Your Honor.
It was the spacing of the joists, right?
That is correct.
And if they determined that the failure to disclose that was unfair and deceptive, that completes the 93A count.
It does, but our argument is because they also found that it wasn't a knowing and willful violation.
But to Justice Hodgens' point, that goes to whether the damages are doubled or trebled.
Our position is that because it's a binding jury count, and there is nothing in the record whatsoever to support that the jury themselves was operating on their understanding that that was limited to damages.
But can I just back up for a moment?
Yes.
Your theory is, or your on appeal, is that the error was in part with the questions that were presented to the jury, that in order for the plaintiff to be awarded for non-disclosure, that the law requires a finding that it was willful and, what was the second?
Knowing.
And knowing, right?
That's correct.
That was not requested. Right.
That's not requested, but I also...
So number one, it wasn't requested, and then the second piece, that there was an error because it was unclear that the determination of willful and knowing only went to damages. But you're saying that that there was an additional requirement that wasn't met here and was required for the jury to deliberate, that not only was it unfair and deceptive, but it was also, because it was based upon non-disclosure, knowing and willful.
Yes. So to be clear, the 93A liability could not have come from any of the failed common law claims because it's a derivative of those claims. So the only liability here would have to come from a non-disclosure. Our argument is because the appellate court in the SJC has found a specific requirement that a non-disclosure to be actionable under 93A requires this knowing and willful requirement, and the fact finder, on a general finding of fact, decided that it was not a no-full and willing practice. If you look at the verdict slip, it specifically asks, was this unfair or deceptive practice knowing or willful? The jury clicked or checked the box for no. They specifically found it wasn't a knowing or willful violation. So when the SJC in the Underwood case finds it needs to be a material, knowing, and willful violation, and the general finder of fact, who is not operating under any assumption that this is a question limited specifically to damages, makes that finding, then that finding should be respected. And
But you didn't ask for a jury instruction to that effect, though, did you?
And to what effect, Your Honor?
About the willful and knowing?
No, the judge, but it was a request. It was in the verdict slip, the knowing and willful.
No. I mean, in the judge's jury instruction, she said, a deceptive act or practice is simply one that has the capacity to deceive. An act or practice is deceptive if it could reasonably cause a person to act differently from the way he would act if he knew the truth about the matter. It includes any communication made with the intent to deceive another person. However, an intent to deceive is not always necessary. Negligent or careless misrepresentation of fact, the truth of which was reasonably capable of ascertainment, may also be a deceptive act or practice. You didn't object to that instruction, right?
No. But I will also say, Your Honor, that the judge did issue an instruction on knowing and willfulness, and it followed the standard case law for that. Knowing is actual knowledge. Willfulness is reckless disregard for the truth. So when the jury was deciding that question, they were operating under that. That's on Record Appendix. I believe that is page 1251.
We keep going in circles, but in order for so you're saying that the error in part was that in order to find a 93A violation, they should have been instructed on something that you never asked them to be instructed of. Then an additional element in non-disclosure is willful and knowing, which wasn't asked. And so the separate piece of damages, you're not disputing that the law is what it is, which is that goes to treble damages. But then the error is in the negligent language that Justice Hodgens, because you don't agree that a person can be found to be liable for 93A violations based upon non-disclosure for negligent actions, correct?
In this case, I don't, so no. I believe a negligent misrepresentation certainly can be the basis for a 93A violation. But what I'm arguing here, this is a failure to disclose a fact that arose after the representation. So after they met with the plaintiffs and showed them the architectural plans, then the engineered plans came back with different spacing from the lumber company. And the failure to disclose that change to the plaintiffs underlies their Chapter 93 account. They didn't tell them that the spacing had changed, and thus that is a material, they alleged a material misrepresentation. And I do want to point out, I do want to contest the materiality. If you look in the record, the architectural plans, as stated by the expert at the plaintiff, contained a finished attic as well. Yet we're here today on squeaky floors and spacing of the joists. So I failed to see how the spacing on the joists, when framing wasn't even discussed, was a material misrepresentation, when apparently the finished attic contained in architectural plans is not a material misrepresentation. I fail to see how we can put those two together and come to the conclusion that this was a material, knowing, and that the plaintiff reasonably relied on this representation of, the notation on the architectural plans that the spacing was going to be 12 inches on center. So reasonable reliance and materiality is certainly an issue here as well. I don't think there's sufficient evidence to demonstrate this was a material representation. Plaintiff was not experienced, was not a builder, none of that. And based on the case law, simply because the defendant here may have known that the plans could change, they change all the time based upon the testimony here at trial. Based upon that, are we really going to say that this is a material misrepresentation and that he should have disclosed this? I don't believe that the record shows that at all.
Yeah, but, I mean, why couldn't this just be a per se violation of 93A? Any person fails to disclose to a buyer or prospective buyer any fact, the disclosure of which may have influenced the buyer or prospective buyer not to enter into the transaction. So if the builder knows that by cutting corners, saving some money, reducing the amount of lumber that's used in the structure, that it might, it might cause some issues. You might have the china cabinet's going to wobble when you walk by and things like that. Maybe the buyer might say, "Well, wait a minute, that doesn't sound right. No, I don't want that to happen." That seems to be what happened here, isn't it? That discussion just never happened.
So I'll take I think there's two questions here. On question one, so the Underwood versus Brisbane case actually expressly deals with that contention of the per se violation of the statute. The case law suggests that that doesn't comport with the statute, making that a per se. That's why the SJC has that additional requirement of a knowing and willful violation. So while the regulation is broad there, it's still, as the Underwood case says, it's still required to be material, knowing, and willful to be actionable under Section 2 of Chapter 93A.
But this goes back to my original question. I don't see any objection to any of this in the jury. It seems to me that the verdict comports with the jury instructions, and there was no objection to these instructions. So what are we supposed to do with that?
Well, the issue here is that there was no reason to believe there was any issues with the instructions. I don't believe there is an issue with the instructions insofar as this. The issue is that there is an additional requirement for, let me back up, there is no claim for negligent misrepresentation or non-disclosure at all. So the jury made no findings specific as to that. So we're, in essence, on a binding verdict, we're operating in the dark as to what the specific underlying claim here. So we have to go back and kind of process of elimination each of the additional claims. And really, it's a non-disclosure issue here. So our claim is that based upon the SJC's specific requirement that there needs to be a knowing and material non-disclosure and the specific factual finding of a jury. This is not the judge making this decision. It's different. The jury is operating under the jury instructions, as the court has pointed out. The jury instructions discuss what a knowing and willful violation is. The jury presumably was looking at that when they were checking that box, and they checked that box as no. So I don't see when a general finder of fact makes a finding as material and knowing, and at the same time the SJC is requiring that a nondisclosure be material and knowing, that finding of fact should, as a matter of law, be imputed to show that this was not a knowing and material nondisclosure and thus is not actionable under 93A. I mean, otherwise, Your Honor, this is, so I will say generally, because as these plans change, right, unless this court wants to elucidate that there's now going to be a requirement that every time you show a plan to a buyer where you have no contract with, you have no privity with, where you show them a plan and say, yes, the house is going to be built generally like this, and then you get the engineering plans back, and you got to go back to that individual and then say, you know, this is all the changes that happened. I just want to go over these with you. Now, if that's what the court wants to do for a requirement, that's fine. I do think it would be massively expanding 93A liability.
It's not so much what we want to do, it's maybe what your client should have done to avoid the potential liability.
I would put forward that I don't believe my client had any duty to disclose minimal changes from 12 inches on center to the industry standard of 16 on center.
The Taylors will disagree with you that it was minimal. The Taylors will disagree that it was minimal.
They may disagree, but I think that based upon it's the industry standard, the house complied with all building codes. This isn't a safety issue. It's nothing like that. The engineer put the plans together, or the architect put the plan together. The engineer created these engineered plans, which weren't created by my client, and then the framing was put together. Now, it's not industry standard, it's not common for a builder to go back and pull engineered plans and point out differences in between those plans to the plaintiffs or to the homeowners.
Were they supposed to build the joists 12 inches apart or 16 inches apart?
I'm not sure how they were supposed to build. They were supposed to build the house in conformity.
The plans state 12 inches, not 16 inches.
The architectural plans do. But there was no contract to dictate, in this case, how the house was supposed to be built by the plaintiffs, by the defendants for the plaintiffs.
But the principal of the defendant sat down with the plaintiffs and discussed the plans.
And generally. And as the testimony came in, there was no discussion of framing whatsoever on the record. So he didn't discuss the framing, and then he's supposed to then go back after he gets the engineered plans. Oh, I know we didn't discuss framing, but there's some small changes. And would the plaintiff in this case, after he said, yep, we changed it to 16 on center, that's industry standard, would they have actually changed their mind and not bought the house? I think it's really hard.
Well, it depends on how you frame, so to speak, frame the issue for the buyers. If you frame it that way, 12 inches on center, 16, that might go over the heads of a lot of people. But if you explain in practical terms what that means, well, you guys are all right with a little wobbly floor here and there, right? Your average person would say, wait a minute, no, I want a floor that you can walk across, it's not going to wobble. I mean,
just, if and I'm out of time, briefly respond to that.
Sure.
No one would have known if the floor was going to wobble. That's not something that was clearly in the record. It's industry standard. This wasn't even discovered until the plaintiffs went in and put their furniture on it. So it's not like it was something intentional or this misrepresentation. No one could have discovered this issue until the actual move-in. So I realize I'm out of time.
Thank you,
Your Honors.
Ms. Chung-Truslow.
I can't tell what time it is anymore, so I'm not sure whether I should say good morning or good afternoon. May it please the Court, Marie Chung-Truslow for the appellees. I am baffled the fact that we are here today because none of the issues presented before Your Honor has been preserved at the trial court level. First question is a question of sufficiency of the jury verdict. You know, whether they got the right jury instructions and they failed to meet those jury instructions. They did not. In other words, there is not a claim that somehow the very same issue before the trial court was made as abuse of discretion. That is the standard here today. My brother is not contesting that the trial court erred in her decision in denying the very same issues that are before this court. There is no claim for that. My brother wants this court to decide de novo the entire trial, to decide whether there was sufficient evidence for the jury to decide whether his client committed unfair business practice. This is not the place in time or the time, for that kind of inquiry. That was done by the jury, and he doesn't fault the jury's decision. There's no error committed by the juries. There's no errors in the jury instructions. There are no errors in any of the motion to eliminate that was filed. There are no errors in any of the submittals that were filed, by both parties. So there's nothing here for this court to decide on except to affirm the lower court decision in finding the jury verdict was valid, and she adopted the jury verdict and rendered a judgment against the appellant. One very critical issue is, the very first issue is whether the 93A claim must be predicated, finding of a 93A claim must be predicated on a willful and knowing. Now, willful and knowing, these are two operative words that are in the statute. It goes to the heart of whether such acts must be doubled or trebled. The judge reserved that very same question to herself, and that's why we have a separate line question for that. In part of the motion to eliminate, she actually said, I'm going to reserve the question of double and treble to myself, so we're going to have a subsequent question after unfair claims, unfair business practice, so I can reserve it for myself. So once the jury decides on that question, whether it's yes or no, then I could, since I'm the sitting judge, I will decide whether the actual damages will be doubled or trebled. That's why that question was there. It had nothing to do with the predicate that somehow if you find a non-disclosure or some type of intentionality in the underlying claim for unfair business practice, they're somehow related to each other. The jury instruction was completely accurate. You don't have to have intentionality or willfulness.
Your brother says Underwood says that it's an added component to a non-disclosure claim.
It is not. It is not. Underwood does not hold that proposition whatsoever. He's mixing language from statutes to cases. Willful and knowing has nothing to do with whether something or a conduct is unfair and deceptive. Unfair and deceptive conduct stands alone. Willful and knowing stands alone. Now, if you have willful and knowing unfair business practice, then your actions may cause a doubling or trebling of the damages. That's all that means.
So can I just go back to your point of all of this is unpreserved and there's nothing for us to do, in essence. But your point being, and when I read the jury instructions, the judge is clear about the elements, and then the judge says, now, if you find that the defendant's conduct was unfair and deceptive, then you have to decide whether it was committed willfully or knowingly. And so your position is that that question was sent to the jury as advisory, so that if the jury came back and said, yes, unfair and deceptive, and yes, willful and knowing, the judge would treble. If the jury came back and said, yes, unfair and deceptive, but no, not which is what they did, no willful or knowing, the judge would not treble the damages.
That is correct. That was the understanding as part of the motion to eliminate. Yes, that was the understanding.
No objection.
Sorry.
Sorry.
I'm sorry.
There was no objection to that?
There was no objection to that.
What about the defendant's position that when the builder sits down with the plaintiffs, there's really no discussion at all about the 16 on center versus 12 on center? What do you say to that?
That's a red herring statement my brother made, because the standard of review by this court is abuse of discretion by the lower court's decision in denying his motion for a new trial, essentially. He brought the very same motion before the court on a motion for a new trial to vacate the judgment, very same issue. And the court decided, no, I'm going to deny that motion because I find that there's no errors committed by anyone. She didn't think she could have committed any errors. My brother doesn't bring up any errors. In fact, my brother says, when asked, are there any errors of law? He says, no. And then where's the error?
What was the nature of the unfair and deceptive act?
There are many.
It's the basis of liability.
We advance many theories, and one of which, of course, is that the builder built a bouncy house. I mean, irrespective of whether there was a 16 on center or 12 on center, he built a bouncy house, and that needed to be corrected because nobody intended to buy a bouncy house. And by the refusal to correct that problem or make repairs to it effectively to subside the bouncing, that alone is unfair. So he doesn't have to have said, oh, the jury, in other words, does not have to have believed that there was a non-disclosure, does not have to believe that there was an intentional or that it was willful. He built a shoddy house, and this shoddy house needed to be repaired. He, in fact, came and said that he would make the repairs. He did attempt once, but never came back. So that's what prompted the lawsuit and hiring an attorney and another civil engineer to get the monetary damages so they can correct the repairs and make the house not bouncy anymore. So, yeah, the jury could have come. That's a problem with sitting here today, is that my brother wants you to second guess what the jury thought, believed.
Well, let me ask you this. If that's all true, could there be any basis for liability for 93A if the plaintiffs never sat down with the builder?
Yes.
How?
Because he still built the shoddy house, and he said that he would come back and correct the shoddy house. He didn't. In other words, he built a house that was supposed to meet certain standards, but he underperformed the standards.
Yeah, but if the special verdict, so was there a contract? No. Was there an express warranty? No. Was there a breach of the warranty of habitability? No. Was there a breach of a duty of care? No. Was there unfair and deceptive conduct? Yes. So
it's a standalone cause of action.
No, but I'm just trying to understand that if there's no contractual relationship, there's no real relationship here between the parties, where is the unfair and deceptive act? It must stem from some interaction.
Yes, he's the builder of the house. The unfair claims, the unfair business practice, the relationship just has to be a business and a consumer of the receiving of the business. And that's what happened here. This is the builder who built a house for them. That's always a part. You don't have to have a legal contractual relationship in order to make a claim for unfair business practice. But in fact, my brother didn't advance that argument. So that's another waived argument before this court. I'm going to submit my argument on paper unless there's further questions for me.
Seeing none, thank you. Thank you both.
Thank you.
With that, I'll call to close our session. I want to thank my panel, the court's officers, the clerk's office, our law clerks, and the court staff. And